Good afternoon, and welcome to our first in our new series of webinars focused on the property life cycle. I'm Stephen Pippard, and I'll be moderating for today. And my panelists I'd like to introduce you to are three panelists: Paul Rayburn from Rayburn Consulting, Martin McKeague from Walker Morris, and Tony Milligan, the head of membership for the CTA. Can I just, guys, go through to an individual and just introduce yourself and your background, starting with yourself, Paul?
Hi, I'm Paul Rayburn. As Pip said there, my business is Rayburn Consulting. My colleagues and I are chartered surveyors operating across the whole of the UK and Ireland in all aspects of commercial and leisure property occupation. So from acquisitions through disposals, rent reviews, lease renewals, etc. So today I'll give my input from the aspect of finding and securing terms to lease a new property. Thank you,
Thanks,
Steve.
Paul. And Martin?
Hi, I'm Martin McKeague, and I'm a partner at Walker Morris. I'm a partner in the property litigation team. Walker Morris is a law firm based in Leeds, operating across the country. From my perspective, I've been involved in a variety of property landlord tenant disputes over the past 20 years concerning rent reviews, dilapidations, alienation provisions. So I'm well versed in resolving disputes and also anticipating from a risk management perspective how to avoid those disputes.
Thanks, Martin. And Tony?
Yes, so I'm Tony Milligan. I'm head of membership services here at the CTA. My background is that I'm a property professional, chartered surveyor. I have a background also in law. I've acted for tenants and I've acted as a tenant. My experience includes running an acquisition program for McDonald's restaurants, so I'm quite used to negotiating heads of terms and new leases.
Thanks, Tony, and thanks, guys, for that intro. Just for the audience there, any questions that you may want to pose, can I ask you to pose them through the Q&A function at the bottom of your screen, and we will collate those Q&As and answer them through the process. Today's process really is all about, and it is a conversational piece really about acquiring a new lease. And on that basis, often tenants come to an overview, finding a property, and often it's about identifying both needs and location. And Paul, really, where would you see the key aspects of a tenant wanting to identify on the process that they need to go through for that identification of a new premises?
Often when businesses come to us, they have already identified a particular property and started the discussions with the owner of that property. Sometimes, of course, it's not the owner. Sometimes they might be looking to take an assignment of an existing lease or a sublease from an existing tenant. And we'll come to the detail of those, negotiating those terms later on. But so often the tenant has identified the property, and then you're straight to negotiating the terms. Otherwise, we will assist businesses in finding properties, working with and helping them shape the parameters that govern what best suits them. But of course, you are subject to local supply and demand functions. Sometimes you have choice, other times your choice is very limited because of properties either not being on the market or existing tenants not coming to the end of leases so you can secure their premises. So we do try to encourage, wherever possible, flexibility in what might suit, in particular in terms of location. And that's more achievable these days for many operations. Offices, for example, when you look at home working, we've learned that offices are perhaps less sensitive to location than they once were. Industrial and workshop premises, similarly. Perhaps therefore the only commercial property type where location is very sensitive is retail, and that would similarly apply to hospitality too.
So, and I guess, so locations sort of one element, and size, layout, amenities. But often the industry is very much geared in terms of a comparable on three major cost parameters: rent, rates, and service charge. And that really, in reality, is just the sort of the top of the iceberg, really, of your occupational cost. Is it worth just exploring what those costs that people need to be sort of aware of when taking on a lease?
Well, the ones that obviously we assist with in advising on are precisely those, Stephen. So rent, rates, and service charge. There won't necessarily always be a service charge, of course. If you are taking a lease of a property where you are the single tenant, you occupy the entire physical thing, then more often than not, the lease will make you as tenant responsible for all the repairs to the building, which can be a very expensive topic, and we're going to come back to that later on. If, however, there is a service charge, which tends to apply when you're occupying part of a multi-occupied building, so it's a unit within a workshop complex, or a shop in a shopping centre or arcade, or a floor in an office block, then there will be a service charge. And that means that as the tenant, as the occupier, you are directly responsible under your lease for the interior, so for decorating and repairing the interior, and the landlord will do works to the exterior and common parts and recharge proportionately, in theory, proportionately to the tenants. So that can be a minefield in itself, and something that advice should be sought on, because, for example, on taking a lease, you may be told that the service charge at that point in time is, say, £5 per square foot. But the next year, the year after you're in there, the landlord uses the opportunity to do a heck of a lot of work to the building, new roof, a whole load of new M&E, new lifts, whatever. And your £5 per square foot, as if by magic, becomes £20 per square foot, which could be crippling. So there are ways of capping and protecting yourself against that, which we advise upon. And rates, separate issue, obviously has been very polemical in terms of being a tax on properties of, in theory, falling value, especially on high streets. So there are obviously steps that can be taken to appeal rating assessments, but in any event, the government is constantly reviewing the fairness or otherwise of that commercial property tax.
So when we approach our members, certainly, there's a whole range of experience, I would say, to say that, from people who've, large corporations that have a property professional in-house, right through to, a sole trader who's never come across a lease, and don't understand the nuances or even some of the terminology, things like premiums, rents, service charge, planning permission. There's a whole host of industry standards that we as professionals come into day in, day out, and it's really, in terms of going through that identification process, I think those key elements are, to understand, does the property give you enough space? Is it the right location determined? What your budget is, incorporating those key elements, but also, is the property fit for purpose for the use that you want to occupy it on? And where would you sort of identify, Tony and Paul, how an occupier should approach those key elements in their first instance, and the professionals that they need to engage with to take that on?
Well, I think largely it's going to be a decision for the occupier, and for the occupier's business. It's going to be a business decision as to what premises requirements they have. And I think when they can engage with a property professional is at the point where they know what they're looking for, or they have a rough idea, and they can give a decent brief to a property professional who can go off and come back with some options, basically. And I think that's really the limit of it. When I was looking for property on behalf of clients, or you know, if it was, you know, for my company, then, you know, we would establish exactly where we wanted to be based on a, you know, a variety of parameters. And I think a lot of businesses know what they're looking for.
And the key terms to you know, once you've identified that property, you know, you've engaged with either the property agent or the landlord. What are the sort of the key terms that the negotiation stands from? If you're literally, you know, you understand rent rates and service charge, it's X, Y, and Z. You're now going into a formal negotiation. A lot of our members and customers often, you know, are intimidated in that negotiation stance and wouldn't know what to look for in terms of, you know, incentives that are industry standard out there. Paul, do you want to just talk through that?
So yeah, so often as a tenant taking a lease of any property, especially if you are not represented, the landlord will make the assumption that if they present you a lease document as something of a fait accompli, then you'll sign it. And sadly, all too often that does actually happen. There might be some negotiation around the obvious points that might concern a tenant, but there can be many hidden points that are effectively landmines. So the starting point will, of course, be the landlord or the landlord's agent proposing key heads of terms. Some might already have been tailored to suit you. For example, they'll say, how long a lease do you want in many locations? And in that is your starting point as a tenant, to build in the flexibility to protect yourself. And therein lies the normal bluff game of negotiations, because you, Stephen, could be the landlord and say to me that you're expecting a 10-year lease. You might give me a break at 5, and I say I want a break at 3. That could become potentially a deal breaker. But then it's to hold your own resolve and not be intimidated, because you might be thinking, look, I'm starting a new business, I'm putting a lot of money into this, I'm pretty sure I can do quite well. But if I find I'm not doing, I don't want to be tied into this thing for 5 years when I might only last 2 or 3, or I might find I'm doing okay, but I need to relocate to more affordable premises, whatever. So building in flexibility is very important. And thereafter, using professionals, lawyers and surveyors, to negotiate the detail of the heads of terms. And the heads of terms is something I think Martin will talk a bit more about. Heads of terms, though, are effectively the key terms for your lease that are agreed by either yourself or by your agent. They are non-binding at that point, even once they're settled in an exchange of emails or letters, but they are the key terms to go into your lease. And they will be the things you have covered there, Stephen, of rent, service charge, if that's applicable. Otherwise, the repairing obligations, who out of landlord and tenant is responsible for what? And like I say, commonly it's tenant for the lot. And therefore, is there going to be, and it's crucial that there is, a schedule of condition with the lease, and clear wording that you as the new tenant are responsible for keeping it in repair, but not handing it back in any better repair than when you took it. And there's a bit more detail that should go on that as well, depending on the condition of the property. So if it's in poor condition, then in fact the landlord has responsibility for fixing things that you're not responsible for. Often in a lease, it can be found that that's actually silent. So the tenants assume that the landlord is responsible for what was accepted as being the fairly badly damaged roof. But then when it starts leaking, the landlord says, yes, you're right. You don't have responsibility for that, but nor do I. So you end up having to do it anyway by default. So things like that you can get caught out on by not having the experience to be able to inform the detail of what you're doing. So those heads of terms, everything from rent, repairing obligations, the use that you're allowed, the use that the lease allows you to carry on in the property, does that fit with what the planning authority, the local authority allows? Just because the landlord's allowing it doesn't mean that the local authority will allow that use. That needs to be checked. Your opportunities to get rid of the lease, can you assign it? Can you sell it in terms of selling on the business? Can you sublet it? And break clauses, the thing I was talking about earlier on, are you going to have a break clause? And just because it's called one doesn't mean it would necessarily work if there are lots of conditions that attach to it. So it needs to be a workable break clause, which might sound simplistic, but there's a lot of case law on what does and does not frustrate the operation of a break clause. So those things are covered in some detail in the heads of terms, and then handed over to a solicitor like Martin to get it right, to make those clauses work. So at this point, Stephen, maybe you should ask if you think appropriate, Martin, a bit more about that.
Yeah, and I guess it's important to stress that it is a negotiation. These are never fixed, and often there's pinch points that can be negotiated by giving in on the other side. So, you know, for argument's sake, if you wanted a shorter lease, do you negotiate at a higher rent to give that flexibility?
Well, a common thing that happens, very good point, Stephen. So a common thing that will happen, but you have to ask for it and ask confidently, I suppose, is obviously a landlord's investment in the property in terms of the income stream. The landlord's investment is worth more the further out the break option is for you, because they've got that reliability of income stream. So a common one might be, look, if you have your break clause at year 5, I'll give you, or you'll negotiate a 9-month rent-free period. But if you want the break clause as early as year 3, it's only a 3-month rent-free period. And when you think that through, that is quid pro quo. That is on its face, that's a fair exchange. So that's fine. It's just not giving into the, well, look, the break clause is going to be at year 5, you're not getting one at year 3, and it's the same rent-free period no matter what. That doesn't really necessarily seem balanced and fair, does it?
No, and I guess, you know, that negotiation is key in terms of setting out the formal arrangement between both parties, the landlord and the tenant. And then once that's agreed, it's then instructing a lawyer at that point. Or Martin, would you see a lawyer being involved at any point sooner than an agreed heads of terms?
I think it's quite often the case that a lawyer will be asked to comment on the heads of terms. I think it makes sense to get their input into it. I mean, I suppose ultimately it's important to recognise that the role of the solicitor is to document the terms that have been agreed, not to negotiate the deal. But that's not to say that a good solicitor won't seek to iron out the creases in the deal. And certainly, yes, I'm often asked to look at heads of terms, see what I think to them, particularly on a complex deal. Then it does make sense to get the solicitor's involvement. There's no point in agreeing a deal that doesn't actually work, because then you've just wasted an awful lot of time. And as a tenant, occupier, even a developer, then you're going to want to get on with your scheme as soon as possible. So it does make sense to get legal input early on. I think to come back to, I mean, Paul's covered a lot of ground in what he's said there. From my perspective as a litigator, the big issue is at the outset, and the big hidden cost, and the one that tenants often don't put into their appraisal, is dilapidations. I think that's the big issue for tenants, that it is a hidden cost, because you can look at the heads of terms, can't you, and say, look, the rent's this, might be a fixed service charge, so those are fixed ascertainable costs. You might see it says full repairing and insuring lease, and that in one sense looks quite harmless, but in reality that can be an absolutely killer of reliability unless you get it right. And as Paul says, you do need to have that schedule of condition there to protect you. And another point, to come back to what you were talking about, Stephen, in terms of making sure the site that you find actually works for you. Well, don't forget that the lease is one part of that. We've also got to make sure that you've got all necessary other third-party consents and rights as well. No point in taking a lease that gives you permission to use it for a cafe if actually you've only got planning consent to use it for a retail shop. So you've got to make sure that those things are aligned, and that's your responsibility. That's not the landlord's responsibility, because the landlord will often say in the lease that I give no warranty that these premises can be used for the purpose which you want to use them for. So it's the heads of terms are obviously central to it, but as a tenant, you need to also be aware and cognizant of the fact that there will be other factors in play as well.
And I guess that sort of goes into the negotiating, the due diligence you take on acquiring any new property.
Yeah.
And often what you see in any of the documentation in there is it's subject to contract. And
Yeah.
what we see from an awful lot of our membership is that they start incurring quite a lot of, and can be significant costs into determining whether a building and a lease is fit for purpose. And actually, there's no contractual obligation to agree those heads of terms until the actual contractual exchange. And so you can run up quite an awful lot of costs in terms of doing this with no right to occupy.
Yeah, but I think that's very true. And as you rightly point out, Stephen, that the deal is subject to contract, which means exactly that. But until you've got a contract, you have no binding, you have no interest or entitlement to take possession or occupation of the property. I suppose it's equally the case, isn't it, that you've probably got to spec a little bit of money to actually ascertain whether that particular property is suitable for your purposes. But so in one sense, agreeing heads of terms, you can't then sort of sit back, light the cigar and say, right, we've all done it now. That's only part of the story. You've then got to get on and actually get that lease or agreement for lease documented. Now, that process itself might take months. In a particularly complex deal, you might need third-party consent. So it's not unusual for the landlord and the tenant to agree that the tenant can occupy the property on an interim basis, say pursuant to a license or a tenancy at will, pending completion of those documents. But it's equally important to recognise that that's a short-term arrangement, and sometimes short-term arrangements become more longer-term. But unless and until you get that agreement for lease or lease completed, then you will have no long-term security of tenure there.
And I guess we brought up quite a few sort of terminologies there regarding lease, and it's probably worthwhile just sort of discussing those different terminologies in terms of, Paul, you mentioned before, whether it's an assignment, a sublease, a new lease, or a license. Tony, do you want to run us through in terms of what those elements mean to an occupier?
Yeah, I mean, if you want to take it from the list that you've just given us, I mean, assignments, you're taking on effectively a second-hand lease. If you're taking on a new lease, obviously you're free to negotiate the terms of that lease. You're not bound by terms that someone else has negotiated. But depending on which location you're looking at, that might be the only option. You might only be able to take on an assignment, and you're also taking on that liability as well. So I think you have to be quite careful when you're taking on assignments, just as you have to be careful in taking on new leases. There are plenty of pitfalls in both. The actual quality, if you like, of the interest that you take in a property does depend on what document you sign. And if you only sign a license, then you don't end up with a legal interest in the property. You have fewer rights. And I'm sure Martin can expand on that. But yeah, you have to be very careful to understand what it is that you're signing in terms of your property contract, if you like.
Thanks, Tony. And I think, bringing that to you, Martin, in terms of the lease and the role of a solicitor, it is trying to understand that sort of possession right, I guess, to some extent, of if you were into a lease to occupy or a license or a tenancy at will, and the rights that you have during that interim process, I guess.
Yeah, I mean, I think for these purposes, whether something like a license or a tenancy at will doesn't give you an entitlement to any long-term occupation. A tenancy at will is terminable at will, and that's by the landlord or the tenant. So that cuts both ways. A license can, in theory, provide for a long, lengthy period of occupation. There's, you know, in principle, there's no reason why a license can't provide for several years' worth of guaranteed occupation. But typically, a license would be short term, it'd be for a matter of months, just to allow the parties to complete the more formal legal documentation. But the short point is, unless and until your lease or your agreement for lease is completed, then the tenant's rights are precarious and can be brought to an end at fairly short notice.
And I guess, you know, over the years we've seen, you know, the security of tenure is quite key in terms of a tenant's rights, and we often see agreements that say they're inside or outside of the Landlord and Tenant Act. Do you want to just describe what that means? Because often, if you're being asked to sign something outside of the Act, you're actually then having to sign a legal document to sign away those rights. Yeah,
I mean, I suppose the starting point for that is, well, what is the Landlord and Tenant 1954, and what protection does it provide? I mean, and that's a, you know, that's a subject which, you know, we could spend several hours talking about. But in short, it provides business tenants who have within their tenancy the protection of the Act with an automatic right to a new lease upon expiry of their current lease, subject to a maximum term of 15 years. And if the landlord tenant can't agree what those terms are, then in those circumstances, the court will determine those terms. The landlord does have certain rights to take back possession, for example, on the grounds of redevelopment, or if it wants to occupy for its own business purposes. But it provides the tenant with a safety net to stop the landlord, I suppose, essentially removing it from the property or holding it to ransom by proposing what it regards as being unreasonable terms. If you are asked as a tenant to effectively have your lease outside or excluded from the Landlord and Tenant 1954 Act, then essentially that means that you are giving up your right to an automatic new lease at the end of the current lease. And in those circumstances, then once your lease expires, you'll be required to vacate. So it is quite a significant step to take. It's a step which I wouldn't suggest anybody take without seeking proper professional advice. And indeed, the whole regime of excluding the tenancy from the Landlord and Tenant 1954 presupposes that you will seek generally, you will seek legal advice in that regard.
And is that not where a statutory declaration is really required to sign away that right of?
Well, yeah, you don't always need a statutory declaration. There's two sort of ways of getting through the gate of excluding the lease. One is through signing the statutory declaration, and that's where you don't want to give a 14-day notice. So if, for example, you want to complete the lease tomorrow and you want to exclude it from the Act, you need to serve a stat dec to exclude it. If, on the other hand, then completion is not taking place in the 3 weeks, you can go through the 14-day notice period, and in those circumstances, a statutory declaration wouldn't be required. So there's two methods that the landlord and the tenant can adopt in order to exclude, and it's only the swifter method which requires a statutory declaration.
Thank you for that. Please do keep posing your questions and bring them into the Q&A session. I guess there's a lot of areas of concern for a new lease or signing, you know, what can be quite an onerous contract for any new tenant. Paul, is it, you know, typical pitfalls that you would see and want to avoid as a tenant moving in or signing a lease? What would those sort of, you know, red flags be?
And so three, I suppose I've already briefly covered. One, about making sure you build in flexibility, so a break clause that works. Secondly, we covered service charge. If you have service charge instead of a full repairing obligation service charge, then there needs to be, ideally, there needs to be a cap on that. So yes, you're telling me it's £5 per square foot this year. I can afford that. I want a cap, so it's that amount subject to index linking, for example. But there needs to be, otherwise it is open-ended, blank checkbook for the landlord. On that note, therefore, if you're taking on a full repairing and insuring lease, so a standalone building, a shop on a high street, whatever, standalone building, with that full repairing lease, as Martin was addressing just now, that can be the single biggest bombshell, which you give the least attention to at the start, but which becomes the schedule of dilapidations that the landlord serves at the end. And a common misunderstanding, this is more a point for Martin really, but I don't think you'll mind me covering it in this relatively simplistic way. But a common misunderstanding is that if you take on a lease of a building that's in fairly poor order, then, and you have a full repairing lease, then so long as you hand it back at the end of the lease in much the same condition as how you took it, then you're off the hook. That's fine. But that is not the case. So in England and Wales, the common wording of a lease, a full repairing clause, is to keep the property in good and substantial repair. Well, if it was already in poor repair when you took it, what is implied at law is that you have to put it into good repair, i.e. better than the state it was when you took it. And that is a common thing that catches tenants out and is crippling in terms of its cost impact, when at lease expiry, you maybe have an expectation of a dilapidations liability of, I'm just going to make numbers up now, but 10 or 15,000 pounds, and a claim comes in at 10 times that. So that can be quite horrific. So the ways of avoiding or damage limitation for that are the schedule of condition that we were talking about. So I'm not obligated to hand the property back in any better condition than is evidenced by, and that schedule of condition is clear quality photographs taken by a professional, by a building surveyor, and annotated to illustrate what the problems are with the building. But like I say, that in itself isn't necessarily enough protection if the landlord has no obligation to remedy things that are wrong during the currency of the lease. In other words, you end up being responsible for them anyway, like the leaky roof scenario I covered earlier on. So those two elements, and then I said there was three, didn't I? Can't remember what the third one was. I'm sure somebody else can tell you another particular pitfall, but flexibility and then service charge oblique repairing obligations would be the things I would always be most concerned about.
I think also, Paul, with regards to any lengthy lease, certainly any lease for 5 years or more, then you're likely to have a rent review provision within that lease. Sometimes that will be fixed rent reviews linked to RPI increases, and sometimes it will be an open market rent review. If it's an open market rent review, then you know, I think a good solicitor there is worth their weight in gold, whether acting for landlord or the tenant, because rent review provisions can be quite sort of esoteric in their nature, and therefore then, you know, as a tenant, you can see what the rent is on day one. You can't necessarily see what the rent is going to be at year 5, and therefore then, you know, you need to ensure as far as is possible that those rent review provisions are drafted in a balanced way, I guess. And from my perspective, sometimes you can see rent review provisions which are drafted in a very unfavourable way, whether it's from a landlord's perspective or from a tenant's perspective. And it's because, you know, the one solicitor has really had their leg lifted in those rent review discussions and that. So I think that's another potential pitfall at the outset, which you know, does need to be sort of carefully managed.
Yeah, and I guess where you're relating to there is things like upward only rent reviews, which some industry professionals can say is an industry standard, and I've seen that quoted a number of times, where, you know, as you say, it goes to market rent, but will only ever increase, even if the local rents are much lower.
Yeah, I mean, there's been debate over that for many years, Stephen. Obviously, you can understand why landlords want upwards only, because who wants a reduction in their income, but why tenants feel aggrieved at that when they may have had a reduction in their income, their turnover, yet the rent goes up. But it's less of a polemical issue now than it has been in the past, simply because leases are shorter. So when, you know, your average lease now is 3 to 5 years of any commercial property type, you therefore have more lease renewals than you do rent reviews. So in lease renewals, Martin briefly covered the Landlord and Tenant Act 1954. If you end up in a contentious lease renewal, i.e. it could go to court, very few do, but it could go to court. The lease, the rent under the lease is actually the methodology, not the precise formula, but the key principles which determine how the new rent will be calculated are actually set out in that 70-year-old Act. And that is that it will be the then open market rental value. So the rent can fall at lease renewal is the important thing to know. And that's probably the greatest protection that the 54 Act does give. However, to use an analogy, in Scotland, for example, there is no Landlord and Tenant Act protecting tenants or entitling tenants to a new lease. And yet the ransoming that you might assume happens at lease expiry doesn't tend to happen. I've seen it from time to time in very strong property markets where landlords are therefore looking to be opportunistic, if you like, turf a tenant out, get a new tenant in. It rarely happens. It's unlikely to happen in retail anytime soon, is it? Or in offices. Some industrial units possibly. So certainly in England and Wales, if I had to put my bet on which commercial property types you are best having 54 Act protection on, I would say it is probably industrial and sheds and warehouses, because they are the buildings most in demand. So where you might get that rental inflation, where you might be pushed out at lease expiry. Generally offices and retail, that's far less likely. So the rent review hot potato, if you like, is far less of an issue now than it once was, because there are simply fewer of them, fewer events of them. There are more lease renewals, which are still, you still need I mean, we have a separate topic upcoming on that webinar upcoming, don't we? But you still need a valuation surveyor to negotiate the best rent, the minimum rent for you, and then a solicitor to take what will still be heads of terms, as if it was a brand new letting, still be heads of terms for your lease renewal, and document those in a way that best protects you.
I suppose that this seminar proceeds on the basis that it's a new lease, and Paul's quite right that most new leases probably won't get beyond 5 years, so rent reviews don't arise. A lot of rent review disputes you see arising on 20 years, 25, 30-year leases, which were commonplace in, I suppose, what, the 70s, 80s, even into the 90s. But I suppose there will be circumstances where a tenant will take an assignment of a lease like that.
That's true.
And therefore then may find itself, in a couple of years' time, generally on a 5-year review pattern. So if you take an assignment and the lease has got 7 years left to run, you're going to be having a rent review in a couple of years' time. So it's equally important to sort of get some visibility of what's the rent going to go up to, because it will be upwards only. If we're talking about old leases, what's the rent going to go up to at that juncture?
That's a fair point. Yeah, you'd need the surveyor's input to give you that advice as best they can. Where's the market likely to be going? Yeah. Am I facing much of an increase, if any, here?
Yeah, but then it also feeds into the point, doesn't it, which is Paul's point as well, that at the moment, if you're negotiating a retail lease, you probably want something fairly short term. You want flexibility. You might think, I'm negotiating a shed lease. Well, wouldn't it be great to get, say a 10, 15-year lease, and I'm there. I don't need to worry about being turfed out. But of course, in 10 years' time, the logistic market might have changed, and maybe there's been a renaissance in retail. So it is all, there's a lot of crystal ball gazing that goes on with these things.
And I guess, the current, there's often times in the property life cycle that it favours a landlord in terms of supply and demand. And we come to post-COVID, where most organisations don't understand how they want to occupy business space in the future. And it is it's a suck and see, because flexibility, working from home, all has an impact in terms of how you occupy that space and what your business provision is. Tony, in terms of membership and what sort of key questions and pitfalls that we often see posed to us over the last 6 months, anything that you would want to add in terms of those pitfalls to avoid?
I think the first thing is never accept the landlord's quoting rent. I mean, we see quite a lot of that. where landlords are simply trying it on, quoting exorbitant rents, when if the tenant can actually take a breath, talk to a property professional, and really understand the market, then they can save themselves an awful lot of money from the outset, really. So yeah, the sort of inquiries we tend to get, we're presented with cases where tenants have got a document from the landlord and they're saying, you know, is this the right thing that I should be signing? You know, should I be going ahead with this? And then, you know, at least at that stage, we're able to take a look at it and advise. And if we can't advise, then one of our ASPs can advise for them.
And when you mention ASPs, that's an accredited service provider, which both Rayburn and Walker Morris are as part of the CTA provision, where we advocate and promote those services that we have accredited as providers to our membership. Sort of moving on from that, I guess we've mentioned the Landlord and Tenant Act, and we've mentioned, you know, it's a 1954 Act, and it is, you know, historic to some extent. You know, and of late, there's been a lot of presses, is the Landlord and Tenant Act fit for purpose? And I'll quote from the Managing Director of Hammerson. He stated that lease structure in the UK has not been fit for purpose for some time. And things like upward only rent reviews probably are part of that. What's your view, panel as a whole, and I'll go through it individually, on, you know, that fit for purpose and what we think the major changes will be moving forward? Tony.
Yeah, I mean, we've gone through a period of extreme change in many markets, mainly as a result of the pandemic. But before the pandemic, we began to see the disintegration of the high street, for example, and a lot of landlords are having to look at the sort of deals that they're offering tenants. Shopping centres have had incredibly hard time, and that's presumably why you've mentioned Hammerson. You can understand why landlords are willing to be more flexible these days, really. And it's an opportunity for tenants, not just in the retail sector. I think, a lot of other sectors have seen a lot of change as well. We'll probably see similar flexibility being built into new office leases, for example. I think it's a sign of the times, and I think it's a really good opportunity for tenants to get the right deals.
Any comments on that, Paul or Martin?
I think it's difficult to sort of treat the market, isn't it, as one whole. Clearly, there are segments which are performing well, segments which aren't performing well at all. But from my own perspective, I think that the last 18 months has accelerated trends which might ordinarily have taken a decade to sort of come to pass, and that's obviously led to some fairly sort of painful experiences on both the landlord and the tenant side. Clearly, it's not a great time for landlord to be in the retail market. Hasn't been a great time to be there for some time. Equally, in terms of logistics, industrial sheds, health, food, those seem like more resilient sectors, don't they? But I think the point about the 54 Act is that it obviously is of its time to some degree. It's perhaps has less resonance or relevance, certainly in the retail complex anymore, simply because the amount of supply exceeds demand, and the 54 Act presupposes that the reverse is true. Frankly, if you're a well-capitalised, well-run tenant business, you'd have landlords falling over themselves to offer you their premises. So I think it does have less resonance there, but I still think it serves a very useful purpose in other sectors, and I think it plays an important role both for the landlord and the tenant, I think, in terms of sort of giving balance to their competing interests.
No, I agree, Martin, and I think therefore it probably does have less relevance today, but the relevance that it does does have is in probably protecting the smaller tenants, those who landlords wouldn't necessarily be falling themselves over and feel falling over to sign up and feel that they can perhaps treat with a little bit less respect, if not some disdain. So it helps balance those negotiations, or the starting point for negotiations. It levels the playing field when it comes to lease renewal. So I think it still has its part to play for that reason. In terms of altering and modernising it, it kind of does what it says. You know, you can have the length of lease, if it's determined in court, will be the length of lease that suits both sides as best it can. So a judgment, I guess. The level of rent is the open market rent. You know, those are and otherwise the terms will not be vastly different to the pre-existing lease unless they can be justified. So it's a balancing exercise, as you say, that does distill out of it fairness. So I don't think it will change much under the current review. I don't know what you reckon, Martin. Do you think there'll be anything to significantly change in the review that's ongoing of the 54 Act?
No, I think there are. I think there are probably more pressing issues the government has to deal with in a wider context, also in a property context, than the reform of the 54 Act.
Yeah.
Thanks, guys. And questions coming in. There's two that need addressing, and we've mentioned this quite a few times during this seminar. Is the word dilapidations and what actually that means. And through this series, we're actually, today was about negotiating a new lease. The next in the series will be about renegotiating the lease, then rent reviews, lease renewal, and we've got a final session purely on dilapidations. But Paul, do you want to just answer that question? Is from a question there is, what do we mean by dilapidations?
So briefly, in putting that in fairly everyday language, at the end of the lease, you as tenant have had contractual obligations to repair, redecorate, and to reinstate, in other words, put back as it was, any alterations that you might have carried out during the lease. Very seldom have any or all of those works been done by a lease expiry, and the landlord therefore serves a schedule of dilapidations. So they get a building surveyor to go around. There are lots of different types of surveyors, but a building surveyor goes around the property, comes around your property, and armed with a copy of the lease, identifying what your obligations was, finds things wrong with it and prices what it would cost to put each one right. That schedule in an Excel document is served upon the tenant, normally by a solicitor, to make it extra scary, and there's usually a big sum at the end of it. And you have a right to negotiate that. And those negotiations go ahead, and a sum is settled upon as damages. So a sum is paid to the landlord as damages for those breaches of covenant. In England and Wales, and we'll cover this in far more detail in that final seminar in this series, as you said, Stephen, in England and Wales, there is a cap on the amount of dilapidations that a tenant pays, and it is the lower of the cost of doing those works that's been negotiated between the landlord and tenant's building surveyor, the prospective surveyors. It's the lower of that sum, or the impact that those breached covenants have on the property's value. And often the impact on the value is far less, because the property is going to be altered going forwards, repurposed, changed into something else, refurbished, whatever. And those works will, of course, as common sense tells us, override perhaps a lot of the things that are being claimed that you should have put right, and here's a price for putting them right. So it's that's what dilapidations is all about. It's the disrepair at lease expiry. Big subject, which is why we've got a separate webinar on it.
Thanks, Paul. And another question that's come in is on security deposits and its protection. I don't know, Martin, in terms of advice, particularly a new tenant coming in, often, dependent on their financial status, a landlord will require some sort of security, and that is, a rent deposit, and that can be, it can be 3 months, it can be 2 years to some extent, I've seen. And often this can be a significant amount of money that is given to the landlord. And I guess, what is the protection for the tenant on that security deposit?
Well, as you say, Stephen, the security deposit will be needed if fortification of the tenant's covenant is required, and security can take the form of a number of different ways, and the most common is by a rent deposit deed. I think the short point is really that the tenant doesn't have a great deal of protection. At the end of the day, the deposit is there to provide security for the performance of the tenant covenant. If the tenant doesn't perform its covenants, then the landlord can draw down on the rent deposit monies. If, as sometimes happens, you end up in a situation whereby the landlord has drawn down on the money and shouldn't have done so, well, then the landlord will then have a claim against the landlord for the recovery of those monies. But I think those claims are few and far between. I can't think of a litigator I've come across many situations whereby the tenant has had to launch a claim to recover its rent deposit monies. If those monies are still held at the end of the lease, often those monies are just used and they're set off against the dilapidations liability. That's the most common outcome. You might find that a tenant is perhaps unhappy because it says, well, look, my liability was £30,000. The landlord says it's £60,000, and the landlord has taken all of the rent deposit monies against that £60,000. But the protection there is essentially one that if the landlord draws down on the monies, and it shouldn't do, the tenant then has a claim against its landlord to recover those monies.
And I guess
there's an important general point to stress there, really, in that before a tenant hands over their money, there should be a document to record the rent deposit. Quite often we see tenants coming to us saying that the landlord won't return my deposit, and they don't have any documentation to prove that they actually handed over the money in the first place, which can cause all sorts of problems.
That's quite right, Tony. There should be what's called a rent deposit deed entered into, which records the payment and records the landlord's obligations and the tenant's obligations in relation to the deed. I mean, one point to note there is that it's often a term of those documents that if the landlord legitimately draws down on the rent deposit deed, the tenant will then have an obligation to top up.
Yeah, and I guess there's various protections in residential rent deposits and schemes that run there. And if it's a significant amount of money, are there opportunities to put it into things like escrow so that both parties are aware of the drawdown before it happens, rather than being used in someone's P&L to expand a business?
Well, I mean, it depends on the terms of the deed. I mean, typically speaking, the deposit monies should be ring fenced, and the landlord shouldn't be able to actually spend them on anything else. It would be an unusual document that allowed the landlord to basically use those monies for some other purpose. So they should be ring fenced in that sense, Stephen. But I suppose it comes back to the point, doesn't it, that ultimately, if you are going to be asked to pay the rent deposit money, there is sense in having a solicitor advise you in relation to that, and also to draw up a suitable rent deposit deed to record the parties' obligations.
And that's the key, isn't it? Is that is to protect that money in some way by a rent deposit deed, or have it documented that rent deposit has been paid.
Yeah, and also I think, as Tony said, it's also important to set out the parties' obligations in relation to the use of those monies, and in what circumstances those monies can be drawn down, in what circumstances those monies need to be returned to the tenant. I mean, your point about residential protections are far greater in scope and extent than they would be in a commercial context. The commercial context really is it's just a matter for the individual negotiation between the parties. There's no intervening statute there that would assist the tenant.
Great, thank you for that. And there's been another final question come in, and I know we're running out of time, so this will be the last question. Is that, Tony, I'm going to pose this one to you. Is that a business is looking to sign a lease with the intention of expanding, and is it worth that business discussing those plan of expansion and agreeing that within the lease, or do they renegotiate that term when they're ready to increase in capacity?
Well, I think I'll assume that when we talk about expansion, we're talking about expanding in terms of space. So I think it'd be important to begin a discussion with the landlord from the outset to make sure that additional space would be available. And that will involve discussing a business plan with the landlord. You don't have to hand over all the details of your business plan. You just really need to speak about the sort of space requirements you may have in the future, and see whether that particular landlord can accommodate them. And I think you need to think very carefully if that landlord can't accommodate that space requirement in the future, because then you'll be looking at relocation and all the costs that are associated with that, which, you know, many of which we've talked about today.
Briefly on that, Tony, there are, depending on the scale of the tenant and their covenant strength and the nature of their operation, you can have maybe an option agreement built into a lease. So we've negotiated several times, for example, where the space is industrial, logistics, storage type space, and there is land adjacent to it that's owned by the landlord, that there is an option which the tenant can trigger, whereby the landlord will build an extension or enable some other usage of that land at a pre-agreed price, pre-agreed rent, and a pre-agreed new lease kicks in. So it's all contractual. You know, anything can be achieved by the goodwill and common intention of both parties. So that's another way that certainty, if you like, of being able to accommodate your expansion plans can be contractually provided for.
Yeah, and I guess that's important in the type of building. If it's, you know, if it's a single building on the high street, your route to expansion is limited, isn't it?
Yeah,
You've got four walls and that's it. But if you're a tenant within a multi-tenanted building, and as availability increases across the building, if you can, as you say, put in a right or an option to acquire as when it comes available, and you've negotiated those terms in advance, then as you expand, you can then implement those terms.
Yeah.
Thanks, guys. We are running out of time, and really the only question to pose to each of you really is a final thought or a key takeaway from any tenant looking to acquire a new lease is what is the one thing that you would sort of leave a tenant to think about or to take away from today's event? Paul?
So mine would be the repairing obligations under your lease. So repairing obligations and service charge, that those are absolutely scrutinised to ensure that you are best protected from any landmines, any unexpected huge bills going forwards.
Thank you, Paul. And Martin?
I would probably share Paul's view, to be perfectly honest with you, that I do think that on the heads of terms, you should be able to see what you're getting into in terms of rent, likely service charge as well. I do think dilapidations and the hidden cost there is probably the biggest landmine, as Paul puts it. And perhaps the fact that both of us have said the same thing is obviously only emphasises that that is the biggest pitfall, really, I think.
That's great. Thanks. And Tony?
Yeah, I think what I would say is, you know, it's worthwhile spending a little bit of money taking professional advice before you enter into this sort of commitment. There are a lot of pitfalls out there, some of which we've touched upon, some that we haven't had the time to cover. I know Paul's mentioned break clauses, but you know, we could have a whole seminar on break clauses and the pitfalls there. But yeah, it's well worth spending a little bit of money at the outset to get the right advice.
Thanks all. And the panelists, all their details are going to be left at the end of this session to get in touch and take any further advice on any of your situations. So all that's left for me is to thank you for your attending and to thank our panelists. Thanks a lot.
Thanks very much.
Thank you. Thanks, everyone. Bye.